All right, so we are live. Welcome everybody. It is Monday the 28th. We are joined today to talk about the NH decision, NH v. Anoka-Hennepin, what that means for transgender students in Minnesota. And I'm joined with folks from Education Minnesota, ACLU of Minnesota, our co-counsel, and then of course I have my lovely legal director from Gender Justice, but I'll let folks introduce themselves. I do want to acknowledge that today is Yom Kippur. We commit usually to having these court chats and community briefings the evenings of decisions coming out. So we recognize that it is a holiday for a lot of folks. And if we had chosen the decision day, I don't think it would have been today, but we hope that folks are able to watch this afterwards. Jess, any added comments?
No, just don't tell anyone I'm here, but
we won't tell. It'll just be on Facebook.
Yeah, no one will know.
So feel free, go ahead and introduce yourself, Jess.
Well, I'm Jess Braverman. I'm the legal director at Gender Justice, and I will pass it on to David McKinney.
Hi, folks. I'm David McKinney, ACLU staff attorney. And in my role, I just briefly, my role at the ACLU, I work with a team of lawyers, law school students, and other advocacy professionals, many of whom provide services on a pro bono basis, including in this case, to execute litigation, legislation, and community engagement strategies around protecting and advancing civil liberties and constitutional rights. And I think with that, I'm going to pass it over to Meg.
Hi, I'm Meg Luger Nikolai. My pronouns are she, hers. I'm at Education Minnesota as a staff attorney. We are the state teachers union, and so we represent basically all organized teachers in the state of Minnesota, as well as other educational professionals. And we are not parties to this case, but we were amici because this issue is extremely important to our members. And so we often participate in issues that have a great impact on the work that our folks do, and especially the students that they serve.
Oh, I've learned a new word. It's amici. And we had numerous amicus, I don't know how we're saying this, and we're going to talk about them, but Education Minnesota did such great work pulling together educators, particularly in the district where we were doing this work. And so I just want to give a huge thank you. Like, teachers continue to show up for students, and it's, as a former student myself, I just like, it warms my heart. Love a teacher. So let's get into the first part of this, and I'm just going to let it's probably going to be Jess or David. So what was the opinion of the court, right? We sued who and why, and then what happened? What was the opinion of the court?
Okay, so let me go first here, because I do want to get the opinion of the court out, and then I want you to translate it into layman's terms. So I wrote down, what's the specific opinion of the court, and then you can sort of say what it actually translates to mean. Okay, so the court basically had two opinions, right? The first was a transgender high school student who was denied use of a locker room that is available to students of the gender with which the student identifies. Such an oddly worded sort of opinion, and to which the student has socially transitioned, states the claim upon which relief may be granted of sexual orientation discrimination under the Minnesota Human Rights Act, a particular statutory reference to it. That was the first holding. And then the second holding or opinion was a transgender high school student who was denied use of a locker room that is available to students, again, of the same gender with which the student identifies, into which the student has socially transitioned, states the claim upon which relief may be granted on an equal protection violation under Article 1, Section 2 of the Minnesota Constitution. Jess, what does that mean? Because I was writing it, and I was like, this is just so, they was sort of stretched it out in terms of the holding, but for the general public, what does it mean?
Yeah, so I speak lawyer and non-lawyer. Erin helped me learn how to speak non-lawyer.
Yes, I'm teaching her, yeah.
It took a lot of work. So basically, we filed a lawsuit saying that the Anoka-Hennepin School District discriminated against our client by forcing him to use a segregated locker room away from all of his peers. So he wasn't using a boys' locker room or a girls' locker room. He was just using a separate locker room that was only for him. And we brought a lawsuit under both the Minnesota Human Rights Act, our local civil rights laws, and the Minnesota Constitution. So our state constitution has an equal protection provision like our federal constitution. And we argued that this violated his constitutional rights too. And what the court ruled was basically that when a school segregates a transgender student and does not let that student use the bathroom that aligns with their gender identity and or forces them to use a segregated and separate facility, that is a violation of our civil rights laws and our constitution. So in other words, schools should be allowing transgender students to use the proper bathroom, or this was a locker room case. So they spoke specifically about locker rooms. I personally don't see any reason why this wouldn't apply to bathrooms as well. But that's basically the ruling, is that it's against our local civil rights law and our state constitution to segregate transgender students or to force them to use facilities based solely on their sex assigned at birth.
Which, yay. And so I just want to be really clear. It was both illegal and unconstitutional, which is just like the worst way to do. I mean, that's like a really huge hurdle to clear, illegal and unconstitutional.
Yeah.
So David and Jess, you've described a little bit about, they segregated our client and that is illegal and unconstitutional. But like, can you talk a little bit about the facts of the case? Like, what was this like for the client? What happened?
David, would you like me to start, or would you like?
Yeah, go ahead.
Okay,
I didn't want to jump in every time.
No, please jump in. We're so excited to have you with us. Why don't you start, because it's always me and Erin talking to each other and we need a fresh voice. So go ahead.
Okay, fantastic. So the facts of the case are pretty concise and undisputed for the most part. And it basically involves NH, who started out at Coon Rapids High School as a freshman. And during that time, he joined the swim team. And while he was on the swim team, he used the boys' locker room to change and to prepare for swim meets and everything without incident. Until virtually the very last meet, when the school district decided that they were going to prevent him from doing so. But so they did sort of a reverse course. They told him he couldn't use it, then they told him he could. And then 4 days later, unfortunately, after that incident with the school district, he went into hospitalization for mental health concerns. And following that, he really got on the school district's radar. And they had multiple meetings in which they discussed his transgender status and his ability or inability to use the restrooms that they wanted him to use or that they felt would be the appropriate bathrooms for him to use. The district constructed they ultimately concluded that he couldn't use the boys' locker room and constructed a bathroom, a locker room separate and assigned it to him to use that locker room. And they told him, against his objection, you need to use this locker room or you'll be disciplined. And not surprisingly, that caused him much frustration, emotional distress. He was stigmatized at school, bullied, and harassed. And so he left the Coon Rapids School District and went on to finish his education elsewhere. So that's sort of the basic facts of the case. Jess, did I miss anything?
I would just add that the school, I believe, was egged on by anti-trans organizations who bring lawsuits around the country, basically trying to push back transgender rights. So my understanding is that the school board was operating on advice they received through like various one-pagers and other sorts of tips that this group was handing out, and they were active in Minnesota handing these things out. And the school, instead of following our own toolkit and our own, which advises schools not to segregate transgender students just because they're transgender, instead of following sound advice, local advice, it appears that they kind of went along with what these groups were recommending. And that's unfortunate for everyone, really.
I think it's worth keeping in mind that this district's history is, even before, I don't think they required a ton of egging. I guess I'll put it that way, because this district has historically, well, not that historically, within the last 10 years, had a suicide cluster. They had been at the receiving end, essentially, of a consent decree following litigation by the Southern Poverty Law Center because of their treatment of LGBTQ students. It is true that there are sort of legal gadflies like the Thomas More Society and the Alliance Defending Freedom, whose job is, well, they've got a lot of hats that they wear, but making trans and other students miserable is one of them. So this is one of those things where it wasn't a drive, it was a putt for the school district.
Yeah, I'm glad, Meg, that you brought that. Sorry, Erin. I'm glad that Meg brought that up, because this was, I think, a significant fact against the school district, that this wasn't just a school district that sort of had a blank slate, was dealing with harassment, bullying, and suicides, resulting suicides from that type of behavior as it related to gay and lesbian students. And so they had a history of these issues that had gone unaddressed. And I believe when, just correct me if my timing is wrong, but they were still under a federal consent order, I believe, when NH started at the school.
I think that's right. The case wasn't that long ago. And yeah, it was Southern Poverty Law Center, and our friends also at NCLR brought this lawsuit against Anoka-Hennepin. And yeah, I think you're right, David. I don't have the exact date, but yeah.
And I think it's like, one of the things that always struck me about this case too is that, so often you hear about the bullying or you hear about discrimination and it's coming from the students or it's coming from the teachers. That was not happening prior to the school board getting involved. And so our client, was on the swim team. He had friends, he had, his coach, he had his teammates. And it was really through the, these hate groups distributing these materials, encouraging other adults to get involved and to help discriminate and bully a child. And Meg, you said they wear a lot of hats, and I never understand a hat that someone picks up that's like, how can I make children miserable and like bullied and experience violence that way? And it's just wild to me. So these were the things that were happening at the school. And so talk to me about the claim. So it's unconstitutional and it's illegal, but like, what law is it violating? What constitutional provision is it violating? And tell me why.
Jess?
So one law that it's violating is the Minnesota Human Rights Act prohibits discrimination in education. And so that's one law that the school's actions violated, was the specific prohibition on discrimination against transgender people in schools. Now, if you actually read the language of the law, it kind of lumps in transgender with sexual orientation. We know those are two separate concepts. This is just the law. This law was actually written a long time ago. I believe we were the first state in the country to expressly protect transgender people in our civil rights laws. And so that's how it was written at the time. But that's where you'll find these protections, both in the definition of sexual orientation, though, yes, it is a separate issue, and the education discrimination provision. The other law that we point to is the Equal Protection Clause of the Minnesota Constitution. I laughed when I said clause. We don't have, like, the federal Constitution has like an express equal protection clause, and we also have one. It's not like identically written to the federal one, but basically we have an equal protection. We have equal protections under the law built into our Minnesota state constitution. That's been long established, and that litigation looks a lot like what you see at the federal courts, but our protections are usually treated as stronger, which is fantastic. So those are the two major claims. We had a couple of, I think there was a due process claim, but the really big ones, I think, that are at play here are the Minnesota Human Rights Act and the equal protection violation. And that's what the Court of Appeals was looking at.
David, anything to add to that?
No, I think that's right. That those are the two main laws. And I will say that with respect to the Minnesota Human Rights Act, it's important to note that the Minnesota Department of Human Rights was intervened in this case. So they became parties to this case and wagged their fingers at the school district to say, you're violating the act in which we are charged with interpreting and enforcing. we say that this is a violation as well. And so kudos to them. I'll also add, and some, we may not get a chance to thank or to even talk about all of the people who were involved in the success of the case. Okay, but the other, notably, the other agency, state agency that also said that the school district was wrong was the Minnesota Department of Education. So, you know, it's sort of every major actor that looked at what the school district was doing concluded what they were doing was wrong and incorrect and in violation of the law, both the statutory law as well as the Constitution.
And that really brings us into the next place, which is, you know, I want each of you to talk about your organization and why this case and this issue is so important. And I'm going to come to you, Meg. You're with Education Minnesota. You know, we're going to talk a little bit about is it the number of organizations that filed amicus briefs, but Anoka-Hennepin Education Minnesota, the National Education Association, and the American Federation of Teachers all filed amicus briefs, and amicus is a friend of the court. So it's basically like, here's what we, people who are interested in this case but are not parties to this case, think, right? Did I describe amicus briefs right? But tell me a little bit about Education Minnesota and why y'all were interested.
So our members are educators, and we represent educators that, you know, in all different positions in schools, but we've got a long tradition in Anoka-Hennepin of trying to be supportive of LGBTQ students, especially up against a school board that isn't always. And then additionally, the Education Minnesota, as well as our international or our national partners, did support the safe student legislation when it was originally adopted. We've always had an abiding interest in making sure that students feel valued, that they feel dignified, that they feel safe in school. And not only and not least, but perhaps most importantly, because they're humans and they deserve that, but also because it's really important for their educational attainment. Students need to feel safe in school in order to do well. And more importantly, schools are a place where we can model the values that we want to see to students who aren't, you know, who aren't trans and don't necessarily see themselves as in need of protection, but, you know, as we're there to model, this is how you treat other people. And so it's important for us to see school boards, you know, do the right thing and behave well. And this is a real fundamental, I mean, this is a no-brainer from my perspective.
I hear that. There's some students organizing for things in my own school district, and they wrote, a school that is only fair sometimes isn't fair at all. And it just, that resonates so deeply with me, right? You can't have equitable education for some people. That's not equitable. I want to read a quote because you spoke so well, Meg, about the harm to the students. And I think that is incredibly important, particularly to center that. But there was a quote in the amicus that stood out for me about the effect to educators. And it said, policies that segregate transgender students like NH from their peers are not self-executing. They compel individual administrators, educators, and other public school employees to carry them out. Educators suffer both professional and psychological harms when they are forced to watch and participate in the stigmatization and degradation and that discriminatory policies inflict on children. And when I read that, I was like, oh, that's just so well put, right? Like, it's not like it happens on its own. It requires people to do the discriminating. I loved that.
Yeah, I think it's, so for me, it's always important, you know, we center the students because they really are at the center of this, but it's true that every single part of the school community is affected by this policy. So it's not just NH, it's folks who have to become complicit if they don't want to, and then it's just the people observing it. So that is, I mean, that's hugely important. And in the previous litigation, we saw educators very clearly being put in the middle of what, you know, their real beliefs were, which is that students should be treated equitably, and then feeling like they might have been retaliated against by admin. And so there's aspects of this that there are tentacles, but always we want to center the students.
Yes, absolutely. And I'll just follow up with one of the other quotes from it. It says, allowing discrimination against one group infects anti-discrimination efforts against others. Educators understand this instinctively. Their classrooms cannot embrace diversity in some ways and deny it in others and still obtain the benefits of an inclusive classroom. So that was really beautiful. We are getting questions throughout this. And so we're going to still talk about why it's important to ACLU and gender justice, but I'm going to throw these questions into here. We had a question from Senator Scott Dibble, who we love dearly, who has been a champion for LGBTQ students and people at the legislature. He asked, I've only glanced through the decision, but saw reference to the Safe and Supportive Schools Act. Was that law a factor in the decision?
So I think it helped. The court referenced it in the decision as evidence of the legislature's intent as it relates to protections for transgender students. It was not the court did not, I would say, reach their conclusion in sole reliance on that law, but it was a helpful guidance for the court. Does that sound right, Jess?
Yeah, I think they were trying to figure out protections for transgender people have not always been interpreted. I would say not always interpreted properly by our courts, but not always interpreted well by our courts. And this court did try to figure out, okay, what do I do in this education context? Part of that thinking is like, what's been going on with our government? So this is the Minnesota Human Rights Act. What does the government of Minnesota kind of have to say about these laws and how they bear on transgender students? And like David said, that it wasn't dispositive. They weren't like the Safe and Supportive Schools Act requires this result, but it helped guide them in figuring out what these protections mean and how this court should interpret them in the education context. So I thought it was super helpful.
So they're not strict constructionists, is what you're saying. They looked at things outside of, okay, I've been learning.
Yeah, so they didn't rely on like legislative history or what happened after the bill passed, but it was, they mentioned it factored into their decision. Sure. You're really,
I know, Erin.
It's like, this is more controversial than the decision is like, how judges read laws.
Yes, we have a separate chat where Jess and I break down some of the terms around like the Supreme Court nominee, and that's one of them. So David or Meg, did you have anything to add to that?
No.
I think the only thing I would add is that I think where that is most relevant, and I think that it's an implicit nod to the evolution of understanding of this issue as it relates to students and others. And I'm obviously at some point, as a person who's fundamentally an employment lawyer, hopeful that means that eventually go-ons will go away. But I think that that is evidence of an evolving public understanding of the kids that are affected by the case. Got it.
The next question, and Megan and David, I don't know your whole like docket and your history, but I know Jess is going to be excited to answer this. Does the Federal Department of Education action in Connecticut against our districts participating in the state athletics league that permits trans girls from participating in athletics, could that potentially impact us here in Minnesota?
Yeah, I saw that question and thought Jess is going to answer this one.
And Jess, maybe do a little bit of a primer before you jump into the answer.
So this is a little bit complicated, but the ACLU National has been doing just tremendous work on trans rights. And they are litigating a case in Connecticut, the Alliance Defending Freedom, which is, they bring a lot of anti-gay lawsuits, anti-repro lawsuits. They sued a school in Connecticut for allowing 2 trans runners to run track. And they're representing 2 cisgender runners against the school. ACLU is stepping into the lawsuit to represent the transgender runners, who I should also point out are women of color. A lot of the times the attacks on athletes when it comes to, I don't know what to call it, like gender conformity or whatever you want to call it, really does bear down on athletes of color. So what happened was the Alliance Defending Freedom had a complaint in with the Office of Civil Rights, but then they filed a lawsuit. So the Office of Civil Rights is an agency that can investigate discrimination, but instead of letting that office make a decision, they pulled the case out of there and filed it in court, which ends the OCR investigation. Except in this case, Betsy DeVos nevertheless issued an opinion saying that the school discriminated against the cisgender students by letting transgender women run track. This opinion wasn't grounded in any case law. Most cases interpreting this is about Title IX, discrimination in education. And most cases that interpret Title IX say that the prohibition on sex discrimination includes trans people. So most courts, when they're saying what is sex discrimination and what does it mean for transgender students, find that you cannot discriminate against transgender students. So her read is just not grounded in any current law. It's just kind of what OCR said. But she recently kind of not only doubled down on that, but issued basically, I don't know what to call it, a warning, basically saying that the Department of Education, the Federal Department of Education, wants to pull funding from any school that allows trans students to participate in sports on teams that align with their identities.
And what kind of funding, Jess?
Funding that's set aside to end segregation in schools, race segregation. It's absolutely obscene. I'm not laughing because it's funny. I'm laughing because it's like, what are you gonna do? So right now, the Federal Department of Education is threatening to pull funding from schools that adopt trans inclusive policies in sports. It's horrific.
And
right now we have a
does this affect
situation
us?
where their opinion is in direct conflict with what's basically the law of the land in Minnesota right now, and we'll have to see how it plays out. If there are schools that receive federal funding through Title IX, that funding would be in jeopardy by them being trans inclusive. But I would of course encourage schools not to back down. I think it's appalling, and that case is currently going through the courts, and the courts haven't yet ruled on the proper interpretation of Title IX in the athletics context. In other contexts, they found that it does protect trans students. So I don't know why they wouldn't do so here, but we'll see.
I think
Jess,
we could use a new head of the Department of Education, and we can have that in a couple of weeks.
I was going to ask a question about, just to be clear, because the question was around its potential impact in Minnesota. Removing or withdrawing federal funding is not a legitimate interest that would support discriminating against transgender students. Is that right? Do you agree with that, Jeff?
Of course, yeah, of course. We would obviously, if this issue needs to be litigated at any point, Gender Justice is awake, ACLU is awake, we're raring to go. But it doesn't mean that schools in Minnesota have to discriminate. It's an issue of this particular federal funding and what the impact is on whether or not they'll receive that particular funding that, again, is set aside to desegregate schools. And as we know, Minnesota has one of the worst disparities when it comes to education and race. So I don't even want to, I don't know what the DOE is thinking here. I mean, we do know what they're thinking here. It's
to bully and, dehumanize trans students, which we absolutely will not stand for. At Gender Justice, I'm assuming at ACLU, I'm just going to speak for ACLU and Education Minnesota. Like, we are firmly on the side of not bullying and dehumanizing any students, particularly trans students. And that's what this is an effort to do. And so I appreciate you answering the question and kind of like calling it out for what it is. Hate groups are working really hard to erase trans people from existence, and they work to pit cis women against trans women, and we cannot let them do that either. And we certainly can't let them bring this into schools that say like desegregate or discriminate against trans students. No, thank you. So let's move to, so we talked about Education Minnesota. David, do you want to tell us why ACLU was interested in this case and about being co-counsel?
Well, sure. I mean, more generally, we're interested in these types of cases because we're interested in protecting GLBTQ rights and trans student rights. We've been a leader on constitutional issues and on the equal protection clause specifically in the Minnesota State Constitution for many years. We played an important role in protecting LGBTQ rights for decades. In fact, the ACLU of Minnesota, this affiliate brought the first same-sex marriage case in 1971, and we continue to fight for transgender rights. And then, specifically, NH's story is just so compelling. And after hearing his story and learning the facts of the case and the issues presented and issues that are really in first impression in Minnesota, we absolutely felt compelled to join and protect the rights of students throughout Minnesota.
And we thank you for joining that fight and for being wonderful co-counsel. Like, huge shout out to the ACLU of Minnesota. Fabulous people up and down from top to bottom. I don't know if you have a bottom. It's just an amazing group of people.
Erin, I should also mention, since we're talking about co-counsel and things, not on this call, but also part of co-counsel is our legal director, Teresa Nelson, who a lot of folks I'm sure know since she's been at the ACLU for, I think, over 2 decades now, well established in the community as a civil rights advocate. And also we co-counsel with lawyers from Stinson
Yep.
Tim Griffin and Andy Davis. So we're very thankful for them as well. And then over at Gender Justice, Christy Hall, who's not on the call, but also was a very key player in this case.
Yes. Thank you for that, because I do have a list of we also have to thank these amazing lawyers who aren't here.
Yeah.
I think you did a good job. Jess, do you want to talk about why Gender Justice is interested in this case?
I know it seems odd that Gender Justice would be interested in gender justice. No, we advance gender equity through the law, and what that means is that we strongly believe that there is value in gender diversity. We don't think people should be oppressed or repressed because of their gender. We believe that all students should be affirmed in their identities. We think it's better for the state of Minnesota to do so. And we just think this case is so important for all students, but we also think specifically for transgender students. We believe in trans inclusive feminism. We highly value the rights of transgender Minnesotans and transgender people everywhere. And we just think this case is incredibly important and a big win. We're all celebrating at Gender Justice.
Yes, we are. I want to thank our amicus. I think I'm still saying that right. So a lot of folks put together amicus briefs, and amicus briefs for those of us, because I'm going to put myself in this category, that have no idea how long it takes to write an amicus brief. I mean, a brief is a brief, right? Like you have to research the laws and say why you think what you think. And a lot of folks put in amicus for this. So Family Tree Clinic in St. Paul, Just Us Health, the World Professional Association for Transgender Health, World Without Genocide, Outfront Minnesota, Transforming Families Minnesota, the Commissioner of the Minnesota Department of Education, whose amicus brief was written by the Attorney General's office. So that's Department of Education, AG, and Human Rights. I mean, the whole state of Minnesota basically was like, don't do this, don't discriminate against trans students. Education Minnesota, AFL-CIO, the Anoka-Hennepin Teachers Union, the National Education Association, the American Federation of Teachers, the GLBTQ Legal Advocates and Defenders, the National Center for Lesbian Rights, MP and his mother VF, who I believe are clients in a case.
That's a local attorney filed an amicus brief basically on behalf of his family, and it was extremely moving. And I have to also say, I thought the education amicus was extremely moving as well, talking about the effects of discrimination on all students and all teachers. Those were two definitely standout briefs.
Yeah, it's worth noting, Jess, that, Anoka-Hennepin teachers, so these are the exact teachers who were in the district we're talking about, filed a brief saying we support NH and we don't want to be put in this position. So thanks to Meg and her team for pulling that together.
Meg, can you talk a little bit about what that was like?
Well, it required a couple of phone calls. It doesn't take a lot of arm twisting. And the Anoka-Hennepin Education Minnesota local, so we're the state affiliate, and then we've got locals who affiliate with us, and then we've got the parent internationals. And the NEA and AFT have been part of efforts like this in other jurisdictions. So this was something that they were interested in, but they were willing to let us do the writing just because it was a Minnesota specific issue. And then the local has been involved with this issue over time. And so it took basically no convincing of them. They were on board immediately with wanting to support the student. I haven't worked with the educators who were working with NH specifically. So we didn't, we weren't really asserting facts in the record or not in the record about the student. We just really tried to bring the perspective of, this is kind of educators collectively, this is how we face it. And that's really the role of the amicus, is to supplement the record, not by talking about the specific facts of the case, but by bringing in policy implications and kind of working the ref, essentially.
Yeah, or guiding the refs to certain things that they can think about.
Right.
I like that. So the next question we have is, and it kind of goes into the last piece. So I think for those of us who are not court savvy, right, like this could seem like, oh, we had a trial and then we won our case, but that's actually not what happened. So in the, oh gosh, I'm tempted to explain it myself, but I'm gonna try to have a lawyer do it. Can y'all explain what this case was filed and then what happened and how did we get this win?
That's
Ooh,
great.
so-
I think
someone-
Erin, you should have done it and we could have critiqued
All
you.
right,
Right?
I can give it a go. Are you ready? Are you ready? I'm gonna give it a go. Okay,
All
here's the deal.
right.
So we filed this case on NH, and the first thing that happens in most court cases is the people who are getting sued will file a motion to dismiss, saying, you should just dismiss this case. It's not a case, judge, you should let it go. And the school district did do that. They did not survive the motion to dismiss. And when there is a motion to dismiss, the judges, they say, okay, all the facts that you have laid out in your briefs, we'll just assume that they're true. And if they are true, does this rise to the level of judging on whether this was illegal or unconstitutional? So we survived the motion to dismiss. The school district appealed that to the appeals court, and the appeals court said, no, this should not be dismissed, because if it is true that you are segregating this student, then you are violating the Constitution and the law. Now we go back to trial to say, okay, did they actually segregate the student? But we have found out that segregating the student, trans students, is unconstitutional and illegal. How did I do?
I mean, this is why you're like an honorary member of the legal team. It wasn't precise, but it was absolutely close enough. Like,
It really was. Yes.
Now a real lawyer can go so that you can just like factually say it.
yeah, it's probably too boring to go into extreme detail. We file a complaint. They can file, if they want to, a motion to dismiss, which they did. The court ruled in our favor, finding that the school did, violate the Constitution and the Minnesota Human Rights Act, assuming everything we put in our complaint is true. So assuming the facts are true. And the facts that we put in there are essentially that the school forced our client to use a separate bathroom because he is transgender. So if that's true, then did they violate the laws? The lower court said they did. Oh, David.
Yes, it's worth noting here that the facts are essentially undisputed, and that's what the school district has said.
Yeah, that's correct, David. That's right. So the questions that the court answered are new. The court hasn't really addressed, this set of facts as it relates to these laws. So the questions went up to the Court of Appeals. Like, did the lower court properly rule that, basically segregating a transgender student in locker room facilities violates the Minnesota Human Rights Act and the Minnesota Constitution? The court, for the most part, upheld the lower court's decision with, minor discrepancies, but it was a great ruling for us. And so now the case can either the school can appeal to the Minnesota Supreme Court. The Minnesota Supreme Court does not accept every appeal. They can say, yes, we'll take this. No, we won't. So we would then have to see if they'd be willing to take it. I assume for an issue like this, they would, but you never know. Or the school the case can go back down to the lower courts for a hearing on the facts, like what actually happened. Though, as David notes, they're not really disputing the facts that we laid out. So I'm not sure what the point of that would be, but that is their prerogative. And then the case could always settle, any number of things could happen from here.
Yeah, Erin, it's also important to note that because this decision comes from the Minnesota Court of Appeals, it has binding authority on all courts within the state. Obviously their boss is the Minnesota Supreme Court, but for all district courts in the state, that's binding authority on them.
See, I learn new information all the time. Thank you for explaining that. And I just want to note that one of our legal fellows says that Jess is too tough of a grader and that she thinks I got an A in my description. So I'm going to take the A, honestly. I'm going to take the win. So I guess I want to start closing us out with, for each of the lawyers to say, like, what, we said what this means, what the win means, but like, what does this mean for students? And Meg, I'm going to start with you because you work with the organization that works with the students the most, or with the educators who work with the students. So what does this mean for Minnesota students?
I think I will start by saying that it means different things in different school districts, because I think there are some districts where we don't have these issues, that administrators are more progressive and that they are a little bit more evolved and they are coming to understand, how we want to meet children where they're at and meet students where they're at. So in those districts, hopefully there will be no change. Hopefully things will continue to go as well as they can and better for everybody. In some districts, it's going to be critically important for them to understand this and understand that they've got to let the students' own sense of self guide how they can participate in activities and move in the school building. And I think that this is going to make life a lot better. This settles an issue that was open and unsettled. And I think that is is huge. And, obviously if this goes up on appeal, hoping, we're ride or die and making sure that this lands the right way.
I love, this is a great place to use ride or die. Like I'm with you. I'm gonna go David next.
So Erin, I think the case really means, and there's a temptation to maybe overinterpret some things, but that's okay. I like to overinterpret when it comes to anti-discrimination laws. I think it means that school districts are put on notice with this decision, that if you are a school district that doesn't have gender inclusive policies with respect to restrooms, with respect to locker rooms, with respect to other facilities and services that flow from the education that students are receiving, you ought to do a top-down review and change your policies, adapt your policies so that they are more gender inclusive and more trans inclusive, and that really, if I'm a school district at this point, I would be thinking, how can I do an audit of these programs to ensure there's no harassment or discrimination? I think that's the overall. I would say that's the larger point of this decision that school districts ought to take in this state. And hey, you've got Gender Justice and ACLU ready to sue if we find discrimination somewhere in the state around these issues anyway.
That's real. And 3% of high school students are currently identifying as trans or gender nonconforming, non-binary. Trans people live all over the state in every district. And so this can't just be a thing that you do at the time, do it now, right? You have students that need you to do this. So I really like that. Jess.
Right now, unfortunately, transgender people, their lives and their bodies are being politicized in really ugly and terrible ways. I know I hate to see it. I think we all hate to see it. And I really hope that trans students see what happened here, how many groups came together to support them, how many attorneys came together, organizations just dedicating tons of time. It wasn't even just, Erin named a lot of the amicus briefs. I mean, there were firms all over Minnesota who were, just itching to help out. I know Fagery wrote a brief. There were firms, even outside of New York. I hope trans students see this and understand that you have a lot of support, and all the ugliness that's going out there doesn't really reflect how people feel about trans students. We think trans students are wonderful. We think that they contribute to our schools and to our state. And we are just so proud to have had the opportunity to fight for your rights. And we would gladly do it again. And we'll continue to do it in this case until this case is over. And we will absolutely keep fighting for you.
I love that.
Erin, can I say one other thing? I mean, make no mistake that this was not an easy experience for NH. The experience in the school district and the treatment of discrimination and harassment wasn't easy, but also this lawsuit wasn't easy. Lawsuits generally are not easy on plaintiffs. The legal system itself is not really built for, being conducive to individuals trying to vindicate their rights. And one of the things I know NH feels strongly about is that this case makes a difference for the next generation. And, there are, to your point, transgender students throughout the state, and they may be experiencing discrimination, harassment, bullying, et cetera. And, may feel like, there's hopelessness that comes with it. But, there's people out there fighting, and, hopefully this encourages them to continue to fight and to try to make the experience for the next generation better. I'm sort of encouraged by and inspired by what NH said. I mean, NH is, this young person. I'm using that word, so I guess I'm old. But this young person, young person who said, I want to make it better for the people coming up. And I think this certainly this lawsuit and what the Minnesota Court of Appeals did today makes that more real for him.
Yeah, and I just want to read a quote. He said, "It means a lot that the courts protect transgender students like me. Today's decision makes it very clear that segregating trans students doesn't just dehumanize us, it violates our legal rights." Yeah. I mean, just 2 sentences and it guts you. It never is lost on me that you said, David, that this wasn't easy, and I don't think NH ever thought it was going to be easy. Lawsuits are very hard, and I think clients go into it knowing that. But to be like targeted by your school board, for your school board to have meetings about you and your body, and it's just, I mean, even imagine just being like the age you are right now as a full adult and having that happen. But as a student, a child, like it's just the height of inappropriate and wrong, and it's discriminatory, it's illegal, and it's unconstitutional, right? Like we shouldn't be doing that. We should be worrying about how to educate students, not how to further marginalize them. I also want to just give a shout out to the Amicus. We have a card, a thank you card that we have drafted to thank all of the organizations and individuals that took the time to do this. And so we will post that in the comments for people to sign that thank you card so we can show all the folks who showed up how many people outside of that are thankful that they showed up. And then I want to encourage everybody to donate to the ACLU and Gender Justice. We are taking these cases, we are doing this work. We are a legal nonprofit, so we just, we exist on donors and sometimes caffeine, I think is what's happening. And I don't know if people can donate to Education Minnesota, but like fully fund our schools and pay our teachers. I don't know, Mike, can you?
Elect politicians who do their job and will be great. Thank you.
Okay, everybody vote. Voting is happening now, so go vote and support teachers. So I'm going to go back to my document and go to the end. What's next for this case? What's next for this case? But you mentioned Goins, and I'd love to hear a little bit about that and what might the plans be for. No, Jess is shaking her head. Never mind. Don't bring that up.
No. I'm shaking my head because that case has been like the bane. So Transgender Legal Defense and Education Fund, their legal director and I used to intern at Transgender Legal Defense and Education Fund back in like 2006 or no, it would have been like, I don't even remember, like 2006 or something. And he like dug around and found like something we had written about how terrible Goins is, like way back then when we were students interning together. It's a terrible case. So that's why I was shaking my head.
Got it. Well, Meg, you brought up Goins, right?
Yeah, I think one of the things that I am, I would love to see the court not, instead of working as hard to distinguish Goins, which they have to do, frankly, at this stage, and it is binding precedent for the Court of Appeals, but we need to see the courts of appeals in the state get to a point where they say that was 20 years ago. It was what we understood at the time. It frankly wasn't that great at the time either, but it's really nowhere near where we're at now in our understanding of people and students and transgender individuals. So that is a case that's it's got to go. But I think that if the Supreme Court adopts the reasoning of this court, it will be a great win for students. I just, as an employment lawyer, I'd like to see the case be sent away.
Yeah, let's say one other thing about that, Mick, since you brought it up. And I mean, Jess and I were talking about this earlier today, and so it's worth noting that if you're an employer in Minnesota and you are an employer within the meaning of the Title VII. Meg even mentioned this, the Bostock decision, which is the Supreme Court decision that came out earlier this year, says that you basically can't discriminate based upon transgender status. So it's unlawful under Title VII to discriminate in the employment setting against people simply because they're transgender. So while the Goins decision is still good law in Minnesota for employers who are protected under employees who are protected under Title VII, they still have federal protections for anti-discrimination because of their transgender status. So employers can't skate by with Goins if they run into Bostock.
And to be clear, Goins is this old case from, 2001, where the Minnesota Supreme Court found that employers, it's not discrimination for an employer to force a trans employee to use the wrong bathroom, but the decision is just grounded in it. I think it just is kind of, what they say is like, traditionally, this is how things are, so we'll leave it. But the whole point is that anti-discrimination laws are supposed to buck tradition in favor of protecting marginalized people. So it's just an outrageous opinion, but it's still on our books. And yeah, like David said, we still think that, first of all, the federal employment laws don't allow it, but we cannot possibly be like the first state in the country to expressly protect trans people and the last state to get it right. We're just not going to allow it. So employers, yeah, absolutely, we will fight for trans employees who are being forced to use the wrong facilities at work.
Yes, and if you are, call us, please. We'd like to know, because we can take down the decision. So are there any closing thoughts from folks? I cannot thank you enough for being here, for doing the work that you're doing. I don't even know if I feel like jubilant right now, even though we've known about this decision since 10 a.m. I feel like this conversation has like helped me really, like, today is a celebration day. I think there's so much that makes us feel like, ugh, everything is falling apart. And today something was built, and it was a more inclusive future for trans students. So do you have any closing remarks? I'm going to start, Meg, with you, just because you're at the top of my screen, so I see you first.
You know, we just felt really lucky to be a part of the work that got done. There was such amazing writing from so many different amici, and the principal brief, of course, was astounding. It was so good. So we were glad to help, and I just think this is a huge step forward, and I'm just, it's really, really a wonderful thing.
David?
Yeah, I mean, I think really everything's been said, but to your point, Erin, I think this is a time for celebration. This was a decision and a marking point in which it shows, I think, how far we've come as Minnesotans. You know, the Goins decision was probably a low mark and was not that long ago. And I think this decision, although on a different statutory framework, different issues presented to the court, it still reflects a more inclusive and equitable environment for the state. And I think that's worth celebrating, and particularly when you know, there's a lot of anxiety and angst right now in our society amongst people, and around just messages that are not inclusive and messages that are, you know, tend to be more hateful. This is one decision that seems to strike at the heart of what it means to be a human and to be in community with others, and to, you know, be protective of our students and the folks who we're entrusted with. So I'm very happy and celebratory around this decision.
Love it. Jess?
Oh, I mean, of course, all of us at Gender Justice are absolutely thrilled. Transgender students, gender nonconforming students, we think you're beautiful and we'll keep fighting for you. And we are so glad that NH brought this fight forward. We are representing another student against the Buffalo Hanover Montrose School District. We'll keep that litigation going. And just know that, you know, with all the ugliness going on in the world, there are so many people who really value you. And that's us at Gender Justice, that's the ACLU, Education Minnesota, and just more groups than I can name right now. Just try to hang in there and remember that there are people who really will fight for you and who don't believe that your problems to be solved. We think you're wonderful people. And we are so glad that there are transgender and gender nonconforming students here in Minnesota.
That's amazing. I'll end with this. I want to thank NH, our client, for going through this process, for being willing to tell his story. And, you know, he really said, like, I want to do this so it never happens to another student. That happened. And our mission at Gender Justice is to advance gender equity through the law. And today we did that, and that feels great. So thank you everyone for joining us. Thank you to David and Meg and Jess for all your work, and for this win for NH and trans students in Minnesota. We will see you, I'm sure, soon for another court chat where Jess and I just talk about random stuff like strict constructionism. Have a good night, everybody.